Welcoming a court decision to declare its former employees, two of them implicated in the VBS Mutual Bank saga, delinquent directors. The ruling means that the former employees, Ernest Nesane and Paul Magula, are disqualified from serving as company directors. But what does it mean to be declared a delinquent director beyond what I've just explained to you? Well, we can now speak to attorney Ntabiseng Dubazana from Dubazana. Attorney Ntabiseng, a very good afternoon to you. Thank you for coming in. So when one is a delinquent director, what does that mean in law?
In law, it means that you misappropriated funds, could be one of the grounds. The other ground could be that you were grossly negligent in your dealings in the company, or you tried to get things for your own personal gain when you were a director stroke shareholder of the company. So the relevant section that deals with this will be section 162 of the Companies Act. So that's when a person can be declared a delinquent director in such circumstances.
So how much room is there then at this point for these two men to maneuver? Can they possibly have this overturned?
They could try. Nothing stops you in law from getting a second opinion, for lack of a better term, to having an appeal from the High Court, take it to the SCA to declare them non-delinquent directors. So they have the choice to do that, but as to whether or not the evidence that was laid in the High Court is sufficient enough for them to have that ruling overturned is a different story.
You speak about sufficient evidence, and one has to wonder, for those of us not familiar with this sort of declaration as an everyday thing, is it a fairly easy thing to do to have a director declared delinquent by a court?
There's not many case law to dealing with that, but it is very easy because you need an attorney, for example. For example, I'll give you a case of Lewis Group Limited and versus Woolmans, whereby the judge or the presiding officer there stated that this thing that I've mentioned, gross negligent misconduct and gaining fortune for yourself from the company, whereby you are now deliberately giving false bank statements, false financial statements, and then taking money from the company for your own personal gain. So it's not about just you're being misguided or you were relying, with less information on something to get something for the companies. That little minor negligences are not considered for you to be declared delinquent. So such huge things that you would have done would be considered for that. So such evidence that was led in court, if it is to that extent, because we know how bad VBS went. So if it can be shown that the monies that were lost in VBS were actually taken by these people, which is probably what is in the papers in court, it will be very difficult for them to get an appeal from the High Court.
So before this, Ernest Nesane and Paul Magula had already, as I understand it, been disbarred by the Financial Sector Conduct Authority. This having happened in March. Legally, what is the difference in sting of these two processes?
Well, from my understanding, they're now disbarred.
Yes, disbarred is what I mean.
They're now back. The disbarment has now been removed. So, as per the PIC's statement, they are now back to be. They can continue in the financial industry, basically. What that meant that when they were disbarred, it meant that when it comes to anything in the financial realm, they are now not allowed to do anything because they cannot be trusted. So now that they've been declared delinquent directors for VBS company or bank in this state, then they were now disbarred. So they can continue with other financial gains and other financial institutions, but not with VBS.
Then the declaration of delinquency then at director level, would that make it easier in law for these two men to face further legal action, be it a civil claim or some sort of legal proceeding?
Most likely they will probably look at a criminal claim. Probably there's fraud involved there. They'll probably look at theft as well. So VBS is looking at such criminal aspects regarding whether they can open a case of theft, depending how much money was taken by these two individuals for their own personal gain from the company. Fraud, misrepresentation of facts, the financial statements that were now handed into VBS, which are not true. So such things can also be open in terms of the criminal law. Civil law, there's also things that they can look at, but for me, I would take the route of the criminal aspect. In order for that, if they win in the criminal aspect, then they have an even better leg in the civil suit.
I'm wondering, you just said earlier that we don't see this sort of thing happen as often as it should, given how easy it is to do. And I'm wondering why it is that companies don't often go this route, especially in a country like ours where you hear of people at director level who are accused of allowing rot to fester at a company or in state institutions indeed, or we often hear about people push for the corruption processes, these people must be criminally pursued. Why don't people go this route of having such a declaration?
Because sometimes it is not as easy. Because sometimes these financial statements, they have to go through audits to see whether or not they really were fraudulent, whether they were not correctly done, whether this person did actually have the intention. Now, the operative thing here is intention. If they intentionally wanted to mislead the company, and if that can be proven, then it's easy to get the directors to be declared delinquent. But if those things are not done, then the easier route is to go through the criminal route, which is easily theft and stuff like that. Because fraud will also be difficult to prove, because you have to prove the intention to misrepresent certain facts. So if you can't prove intention, then you have problems. So that's why not many cases are out there regarding delinquency, but they are there. And the way that they're structured and the judgments in them are so great. I love them, the way they're put. You know what I mean? I get so passionate when I read those ones. Because even though they're not in the limelight, when you are in a situation whereby such cases are there and you refer back to those cases, you're like,
So it's perhaps a legal tool that is underutilized, one could say.
Yes, 100%.
All right, Nthabiseni Ntubazana, thank you so much for your time this afternoon.